Trademarks prevent consumer confusion and distinguish goods in commerce. When you see a trademark, you know who made a product and what kind of product it is. But what happens when two companies try to use the same mark? The 1975 case of Bluebell Incorporated versus Farah Manufacturing Company decides this issue. In May of 1973, Farah Manufacturing Company created a trademark using the phrase "time out" and an hourglass logo for its new stretch menswear and cleared the mark with counsel. Farah didn't apply for federal trademark registration. On July 3rd, Farah sent slacks with the timeout mark to its regional sales managers. Shipments to customers began in September. Unbeknownst to Farah, another company called Bluebell developed a trademark using the phrase "time out" for a line of men's sportswear at the same time. Bluebell's mark used a logo of a referee's hands forming a T. Bluebell cleared the mark with counsel but didn't apply for federal registration. Bluebell already had a line of slacks under the trademark Mr. Hicks. On July 5th, Bluebell began shipping out Mr. Hicks slacks with both the Mr. Hicks mark and its new "time out" mark on them. Bluebell continued sending customers Mr. Hicks slacks with the "time out" mark until August, when Bluebell started producing "time out" products. In September, orders began, and in October, scheduled shipments began. By late October, each company had received more than 150,000 orders. Then, Bluebell found out about the similarity of the marks. Bluebell sued Farah for trademark infringement and unfair competition, seeking injunctive relief to keep Farah from using its timeout trademark on its men's clothing. Farah counterclaimed for similar relief against Bluebell. Both parties sought summary judgment. The district court granted a permanent injunction in Farah's favor. Bluebell appealed to the Fifth Circuit.